Yes, very good afternoon. Very good afternoon. So let us revise for a while, it's a quick recap of what we have discussed in the previous classes. Okay. So let us start with fundamental rights. So we have talked about fundamental rights. Fundamental rights are mentioned in which part of the Constitution? Part 3 of the Constitution. From which article to which article fundamental rights are mentioned? 12 to 35 of the Constitution, correct. So what are fundamental rights? Fundamental rights are the basic rights guaranteed by whom? By the Constitution to the people of our country. Is it only to the Indian citizens that fundamental rights are available? No, because the foreigners also enjoy some of the fundamental rights. Okay. Are the fundamental rights amendable? Can we amend the fundamental rights? Yes, we can amend the fundamental rights. Okay. Then the next important question is, are fundamental rights justiciable in nature? That means, are they enforceable through court of law? Are fundamental rights enforceable through court of law? Yes, fundamental rights are enforceable through court of law. You can approach Supreme Court under which article? 32 of the Constitution. High Court under which article? 226 of the Constitution. So important fundamental rights. First one is right to equality. So it's basically the discriminated related provisions what are all there. So they will be addressed in the right to equality. Then the next important, right to freedom. Okay. So from next one is right to freedom is article number 19, and then next one is right to freedom from exploitation or right against exploitation. Okay. And then freedom of religion, and then cultural and as well as educational rights, and finally right to constitutional remedies. So under article 32 of the Constitution, through this particular article only we approach Supreme Court. Clear, right? And what is article number 13 of the Constitution? Article 13 of the Constitution says that laws which are in conflict with the fundamental rights or which are mentioned in part 3 of the Constitution, so then immediately Supreme Court of India will declare them as null and void. This we have discussed in fundamental rights. So I think there is no need to revise preamble, right? It was pretty clear for you. So the parts, how many parts are there? Parts of the Constitution. How many parts as of now? 25 parts are there. Okay, how many schedules are there? 12 schedules are there. Originally how many are there? 8 schedules are there, correct. So 9th schedule was actually added in the year? 9th schedule. 9th schedule was added in which year? Is it? You people have added it. 9th schedule. 8 schedules were originally part of the Constitution, and the question is? Is it? Okay, no. So the 9th schedule was added through in the year 1951 through First Amendment Act. Okay, under the Prime Ministership of Jawaharlal Nehru. We already discussed all those aspects. What is 10th schedule? 10th schedule of the Constitution deals with like these things ఇవి ఎలా ఉంటాయంటే అప్పటికప్పుడు మనకు చదువుకున్నప్పుడు బాగానే ఉంటాయన్నమాట. But you need to retain them. Okay. So these things are very dead basic and they need to be at your fingerprints. Okay. 10th schedule deals with anti-defection law. 11th and as well as 12th schedules deals with panchayats and as well as municipalities. How many parts are there? 25 parts are there. Originally 22 parts are there. Clear. So that's how parts, schedules, and then we talked about preamble, and then we talked about fundamental rights. This is about directive principles of state policy. Directive principles of state policy, some of the important points. Point 1, just a minute. Yes. What are directive principles of state policy? These are actually the directions which are issued by whom? By the Constitution to whom? To the government of the day. These are actually the directions which are issued by the Constitution to the government of the day. So that means, so the government have to implement these directions when they are ruling for the period of 5 years. Okay. So the directive principles of state policy, if somebody asks you, just tell me in layman terms, what are directive principles of state policy? Directive principles of state policy are basically the directions which are issued by the constitution to the government of the day, or to the government, that you need to implement these directions when you are ruling the country. Then some static portions, in which part of the constitution these directive principles are mentioned? Correct. Part 4 of the constitution deals with the directive principles of state policy. Okay. So then what are 3 other parts? What is part 1? Union and its territories. Correct. Part 2? Citizenship. Part 3? Fundamental rights. We just discussed. What is part 4A? Part 4 is TSPSC. Part 4A? Okay. We will discuss that in the next class. Fine. Okay. So that is part 4 of the constitution. Under article number 36 to 51 of the constitution deals with that of the directive principles of state policy. Okay. So from which constitution we were inspired and we took these particular directive principles of state policy? From the Irish constitution. So generally each and every feature in our constitution we took from one or the other country. Like for example, preamble we inspired from American constitution. Fundamental rights, American constitution. Directive principles, Irish constitution. Okay. Okay. So these are basically directive principles are taken from the Irish constitution. Perfectly fine. Then the next important question is like, are they justiciable or not justiciable, or non-justiciable you can say? Are the directive principles of state policy justiciable or non-justiciable? I hope you already know the meaning of justiciable, right? Justiciable means enforceable through the court of law. Okay, so that means if a particular principle is violated, you can approach a court. That is what is enforceable. Are fundamental rights justiciable? Yes, fundamental rights are justiciable, because whenever a person's fundamental right is violated, so then he or she can approach a Supreme Court or High Court for that matter. Now the question is, are the directive principles are also justiciable? Are they justiciable? Are they not justiciable? You should understand that these directive principles of state policy, they are non-justiciable in nature. Very, very important. Ante, so these directions, even if so these are actually directions given to the government, it has to follow. Let us assume that it has not followed these directions. Then can someone approach court and file a case against government saying that it did not follow the directive principles? Can a particular person can do that? No, because these directive principles of state policy are non-justiciable in nature. So that means even though the government did not follow these directive principles while it is ruling for the 5 years, so then what happens? Then nobody can approach the court and say that these DPSPs were not followed, these DPSPs were violated. Court will say, just simply say that, sir, part 4 of the directive principle, part 4 of the constitution, DPSPs are non-justiciable. So you cannot enforce through us, through courts. You cannot enforce through us these courts. This is how UPSC frames the questions. Consider the following statements with respect to fundamental rights and DPSPs. Both fundamental rights and directive principles of state policy are justiciable in nature. The first point they'll give you. So point number 2, one can approach under Article 32 to Supreme Court when the directive principles are violated. Second point, which of the following statements? 1 only correct, 2 only correct, both 1 and 2 are correct, none of the above. So first question says that fundamental rights plus directive principles of state policy are justiciable. For example, if that is the option. Okay. Option number 2 says that when DPSPs are violated, one can approach the court under Article 32. If the question is, which of the above statements is not correct? 1 only not correct, 2 only not correct, both 1 and 2 are not correct, none of the above. What was the answer then? Both are not correct. So therefore this will be the answer. You should understand whether are they asking are correct or not correct. Okay. Here both fundamental rights DPSP is not justiciable is wrong statement, because only fundamental rights are justiciable, DPSPs are not justiciable. Second point is that when somebody violates the DPSPs, they cannot approach under Article 32 Supreme Court, they cannot approach. Here it is fundamental rights. If it is violated, then they can approach. Okay. These directive principles are very, very important, that Dr. B.R. Ambedkar have called these features as novel features of the Constitution. Novel features. Which of the following parts of the Constitution were regarded as novel features by Dr. B.R. Ambedkar? It is directive principles of state policy which are regarded as novel features by the these things. Clear? Yes? If you start from the first point, directive principles of state policy are mentioned in part 4 of the Constitution, from Article 36 to 51 of the Constitution. These DPSPs are actually the directions which are issued by the Constitution to the government of the day. These directive principles are taken from the Irish Constitution. These directive principles of state policy are non-justiciable in nature. And these directive principles are regarded as novel features by the Dr. B.R. Ambedkar. These are some of the important points. And the next important point is that these are also known as instruments of instruction. Which of the following parts of the Constitution are regarded as instrument of instructions? Directive principles of state policy are also known as instrument of instructions, because these instrument of instructions were actually issued under the Government of India Act 1935. Okay. So the Government of India Act 1935, some instrument of instructions were issued by the British. Accordingly, these are also the instructions issued by the Constitution, but now to the government, that they have to follow. This is another important point that you have to know with respect to directive principles of state policy. Okay, fine. So now let us read some important points. We already read this point. The directive principles of state policy are mentioned in part 4 of the Constitution, from article number 36 to 51 of the Constitution. Okay. Then the idea of having the DPSPs are actually borrowed from Irish Constitution, which in turn has copied from Spanish Constitution. From Spain they took it, and from there Ireland we took these particular features. Okay. Simply, if in layman terms, when somebody asks you what are these directive principles, these are actually by the Constitution, government of the day. Here they will say that instead of government of the day, they will say people of our country. Is it true? When they say, okay, when they say these directive principles are the directions issued by the Constitution to the people of our country, is it true? Is that statement true? Are the directive principles like that? Directive principles are to the people or to the government? To the government. Okay. And if it is to the people, those directions we call it as correct, or fundamental duties, you can say that. It's okay that you have to follow these particular things, you have to do, should not do that, those things. And then we already talked this point as well. It is the Dr. B.R. Ambedkar who has described the DPSPs as the novel features of the Constitution. Okay, most important points, Andy. So directly they'll give you these statements. Okay. They will give you in a trapped way, like they will just tweak the statements and they will give you. So with that makes you confusion. Okay, fine. Then the next important point. This point also we are aware of it. These directive principles resemble the instruments of instructions which are actually enumerated in the Government of India Act 1935. So whatever these instrument of instructions which have been given in the Government of India Act 1935, these DPSPs are also in the similar fashion. And then are they justiciable? Non-justiciable in nature. Non-justiciable means not enforceable by the court of law. Okay. that they are not legally enforceable, but however they are fundamental in the governance of the country. When somebody says that these are not enforceable, will you take it seriously? Now assume that you are the government. Now these are the directions issued to you, that in these 5 years you have to follow these directions. Okay. Now Constitution also said that these directive principles are not legally enforceable. That means even if you don't follow it, so nobody can go to court and say that these people are not following these DPSPs. Now will you take them seriously? Obviously you will not take them seriously, because the people cannot go to the court. Yeah, but unlike on the other side, fundamental rights, if I violate the fundamental rights of the people, then immediately they will go to the courts, and immediately court will ask me that you should restore the fundamental rights. Why you violated the fundamental rights? On the day before we talked about habeas corpus, one of the writ issued by the Supreme Court. Yes, likewise. But now, how come these DPSPs will be implemented? What these DPSP consists of? Important principles DPSPs consists of is, first and foremost thing is that, this was the question asked in the Constituent Assembly by the members of the Constitution. Array, you are not giving these DPSPs legally enforceability. Like fundamental rights, these DPSPs should also be given the legal enforceability. Then only government will strictly follow, or otherwise what it will do? It will take the matter lightly. It will not follow these DPSPs at all. The first important point you should understand is what DPSPs is all about. The fundamental objective of the DPSPs is all about is welfare of the people. It contains the directions in the DPSP which deals with the welfare of the people. So that means you have to provide maternity relief, you have to promote the cooperative societies, you have to provide the good education, scheduled castes, scheduled tribes need to be uplifted. These are the provisions. Okay. Now this was the question asked to the Dr. B.R. Ambedkar. Like, you are not giving these DPSPs legal enforceability, then how come the government will take it seriously? Understood? This was the question that was asked. So then the answer is that the government is elected by whom? By the people. True. Why people will vote only to this government? Why the people should vote only to this particular government? Because you promise something, that when I come to power, okay, what I'll do? See, I don't want crores of money. What I want is good education for my children, good development, health. I want health. Okay, I want safety of women. I want employment. Taking all these parameters into consideration, so whichever the government, whichever the contestants say that I will provide these aspects, then immediately you will vote them. Okay, correct. Now, what DPSPs is talking about? Obviously, you have also asked the same thing, right? So that means whatever the people are asking, whatever the directive principles are mentioning, both are same. They all talk about welfare of the people only. Okay, fine. For example, if I am the government, I promised you that I'll give you education, development, health, safety, employment. So I ruled for 5 years. But now again, I haven't done any developmental activity. I haven't given any job opportunities to you. I haven't brought any companies to this particular thing. Now I'm again, 2 months, just before 2 months, I'm again coming to you and asking you the vote. Arey, please vote me. For the next 5 years, I will do these aspects again. Will you trust me? No. What you will do then? You will just remove me and give the power to somebody else. So that means I haven't followed directive principles of state policy. If I have followed the DPSPs in their true letter and spirit, you might have voted me again, because that is what you wanted, right? So now the thing is that the harsh punishment for me, removing me from the power? So the biggest punishment for me for not following the DPSPs are being provided by people, by not voting them again. This is the explanation of B.R. Ambedkar. Why I am not making them as legally enforceable are because I will give this power to the people itself. Let them decide. Okay, if the concerned government did not take care about the welfare of its people, then the people itself will throw them out, which in turn is clearly the opposite of that. They haven't followed the directive principles of state policy. So that means I can say that when the directive principles are not followed by the government of the day, then it's the people only which will take the decision. Who will take the decision? By not voting to that particular person again. That is the biggest punishment that we can give. Okay, rather than why to involve courts here is what is the important explanation that was given by Dr. B.R. Ambedkar. You have any doubt? Yes? ఎవరండి? Then you should understand which question? You should read, 1 minute. Have you seen this particular thing? That is the explanation. So that means if you haven't done something, that means you haven't provided the employment opportunities, you haven't provided the health opportunities, nothing. Education, no good education is there, no employment to the youth, no companies were brought to the state. If all these things were there, the only remedy that people have is don't vote them again. Don't vote them again. That is the only remedy, and even the same thing that was said by Dr. B.R. Ambedkar. Okay, you cannot approach the court and say that, see, they have not provided the employment, they have not provided the health. No, then court will ask only one thing, I cannot do anything, don't vote them again. Okay, that's what they promised, and they kept their promise, so just don't vote them, is the explanation that they will give. Okay, and even if they ask you, sir, you can do legally, sir, give some punishment to them, then they will say that these are all the directions which are actually issued by constitution to the government, and since these are not legally enforceable, I cannot do anything. చెప్పండి. ఇదండి we will discuss this at the last, Andy. We will discuss all these doubts at the last. Okay, fine. So you have understood that. But however, fundamental right on one hand, for example, if you have been illegally detained by the enforcement authorities, then if you go to the court and ask the court that, so my so and so son, my so and so daughter have been illegally confined, then court says that I cannot do anything. Can court say like this? No, because fundamental rights are legally enforceable, but directive principles are not legally enforceable. So therefore it is the power was given only to the people itself. That is the power of the vote. Okay, through which you have to tell to the government that, so this is the decision that we have taken. This is all representative democracy, right? You yourself have elected the particular representative that he will do something good for you. But if you haven't done, don't vote them again. Yes. Then the next important thing is that, yes. So let us discuss some important things. Some important directive principles. We will not discuss all the DPSPs, whatever important as of now to the basics class, which are must ensure that you should know, we will discuss. In that, first important is Article 37 of the Constitution. The moment I say that directive principles are not legally enforceable, where I have made this statement? I mean, is it mentioned in the Constitution? Yes, it is mentioned in the Constitution, and it is mentioned in Article 37. Then the moment you say that these directive principles of state policies are not legally enforceable, then government will take it lightly. Then immediately, so Constitution of India had said that, but however, these directive principles are fundamental in the governance of the country. Whatever you are governing, you have to implement these principles at any cost, because they are the fundamentals. Okay, if you haven't done these things, then what else you are doing? Because these are all the basic necessities that what people want. These DPSPs are all increase their nutrition, increase their standard of living, okay, prevent the drugs abuse, don't provide the intoxicated drinks, the state has to take all these duties. Scheduled castes and scheduled tribes were, injustice was done to them. Just please bring to them to the marginal, to the mainstream of the society. Okay, give from more education. This is all mentioned in Directive Principles. If you read Article 37, Article 37 states that the DPSPs of state policy are not enforceable by any code. But however, these principles are fundamental in the governance of the country, and it is the duty of the state to apply these principles in making the laws. Clear? These are actually the duties of the state. On the other hand, we have fundamental duties like, fundamental duties were now again given by Constitution to whom? To the people. Okay, originally these duties were not there. Tomorrow we will discuss these fundamental duties. Fundamental duties are also not legally enforceable. They are also not justiciable. For example, likewise, but however, that doesn't mean that citizens should take it lightly. Okay, they are not legally enforceable, no worries. So we will also take it lightly like the government. No, you have to incorporate, you have to perform those particular duties. Okay, so then only you deserve the rights. So, nobody will ask you which article of the Constitution says all these things. So, in one of the Roman numbers of a question, they will say that Article 37 of the Constitution, or according to Article 37 of the Constitution, the directive principles are legally enforceable. This is how UPSC will make a statement. Okay, it will just remove not. According to the Indian Constitution, the DPSPs of state policy are enforceable by any court. Statement number 1. But immediately you should understand that they are not legally enforceable. Clear? This is all mentioned in Article 37. Two important things. Number 1, sir, they are not legally enforceable, but however, you have to follow these because these are fundamental in the governance of our country. Then, next important is Article number 38 of the Constitution. Article 38 is simply talks about only one important thing called as welfare. The entire crux of this DPSPs is mentioned in Article 38 and A. What is the objective? The objective is these DPSPs are all about the welfare of the people. You have to promote the welfare of the people. Okay, these are the directions issued on that particular front. The same thing you can read. Article 38 of the states that the state should work to promote the welfare of its people. This is to be done by securing and protecting a social order that ensures social, economic and political justice. Have you ever seen these three words? Where you have seen these words? Where you have seen these three words? Have you ever seen? Fundamental rights? Preamble. So in preamble, if you see, we have discussed about justice, social, economic and political. Okay, so that means preamble is just an executive document and directive principles are the implemented provisions. So that means whatever the objectives which are mentioned in preamble will be implemented through fundamental rights and directive principles and fundamental duties. That you have to understand. So what is Article 38 is all about? In simple sense, the state, it is the duty of the state to promote the welfare of its people. Okay, what is 37? The directive principles of state policy are not legally enforceable, but these principles are fundamental in the governance of our country. That means the state should not neglect them at any cost. That is what is Article number 38 of the Constitution. Yes, done. Then this was a new article that was added later. A indicates amendment. That means originally not there, but later on added. So this has added something called as, so they are poor population, for example, in our country. They were like, for example, they were arrested by some law enforcement agencies like police. Now, it is their fundamental right to hire a lawyer. Now, can they hire a lawyer? They don't have money to eat the food tonight. How come they can hire an expensive lawyer? So therefore again, that means again if they can't hire the lawyer, what happens? They might not be aware of the legal things that are there. He might be exploited. So what is the duty of the state again? Provide a lawyer. provide a lawyer to those particular poor population, so that you are providing legal aid to them, so that justice will also be provided to those people as well. So that means even though you are poor, even though you don't have money to hire a lawyer, so since it was your fundamental right, the state took the initiative and started providing the lawyers. And this was a direction that was added under Article 39A of the Constitution. Okay, so you can read. Article 39 states that the state must ensure equal justice for all the citizens. It also requires the state to provide the free legal aid to the citizens who may not have the legal opportunities because of due to the disadvantages like poverty. Because of due to the poverty or some other reasons, lack of awareness or any other reason, now the state should step forward and go to that particular person and provide them the free legal counsel, so that they will also be given the legal aid. This fact is important, Andy. Article 39A was later on inserted by the 42nd Amendment Act 1976. 42nd Constitutional Amendment Act 1976. Where we have seen this amendment last? In preamble. What were the acts which were added, words which were added to preamble through this amendment? Secular? Socialist? Integrity, correct. Secular, socialist and integrity. This 42nd Amendment is also known as mini constitution. So those number of changes have been added because of due to this constitutional amendment. And there was a question in UPSC, which of the following directive principles of state policy were added through the 42nd Amendment Act 1976? This is one such particular article which was added through the 42nd Amendment Act 1976. There are some other articles, like for example, Article number 39, one of the important clause of Article 39, 43A, participation of workers in the management of industries, 48A, the state shall promote the environment and as well as wildlife. We will discuss all those articles as well, Andy, no worries, okay, etc. So you should understand first point. Article 39A talks about promoting equal justice and provide free legal aid to the poor population. Whose duty is this? People's duty? Government's duty. This was added through 42nd Amendment Act 1976. Okay, 1976. So now the direction has been there. State has to act. That's the reason it has established something called as NALSA. NALSA. NALSA is an organization that was established. Okay, in order to implement this provision, Legal Services Authorities Act 1987, a law will be made by whom? Parliament, correct. Accordingly, the Parliament, to implement this 39A, to provide free legal aid to the poor, it has enacted an act. That act is called as Legal Services Authorities Act 1987, and accordingly it has created a body called as NALSA. NALSA means National Legal Services Authority. National Legal Services Authority. That means this body is an all India body which is responsible to provide the laws to the poor population. Similarly, at the state level, SLSA. Can you tell me what is SLSA? State Legal Services Authority. Okay, at the state level it will be providing. So what they will be asking you is that in this context, in order to implement which provision of the Constitution of India, National Legal Services Authority was established? A. Article 39, 39A, 43A, 48A. 39A. To implement 39A. Okay, or they will ask you also like this. Parliament have enacted a law, Legal Services Authorities Act 1987, to implement Article 39A of the Constitution. Is this statement true or false? True. Article 39A of the Constitution was originally present in the Constitution. True or false? False, because it was later on added. Article 39A of the Constitution was added through 44th Amendment Act 1978. True or false? False. Why? Because 42nd Amendment Act 1976. This is how, in that tensed environment, you have to eliminate, is that really true or not? So that means your brain should work that much faster. Okay. When it will work faster? When these basics are very clear. When these basics are very clear, what was added through 42nd Amendment, what were added through 44th Amendment, which DPSPs were added through 42nd Amendment Act, what were the DPSPs which were originally there, what were later added, what was the objective of this edition. Only then only you can answer those questions, Andy. We will see at the last, like to an extent, I will see like to what extent you will answer these questions. I have included the previous year's questions as well, so that we will see, understand how these things. So now you are very clear, providing equal justice and free legal aid to the poor population. That is what is Article 39A. Later on added through 42nd Constitutional Amendment Act 1976. And Parliament, in order to implement this particular Article 39A, has enacted something called as Legal Services Authorities Act 1987. And this act has constituted a body called as NALSA, National Legal Services Authority, and at the state level, State Legal Services Authority. Now here the question will come. Statement number 1 says that Article 39A provides free legal aid to the poor population. That is fine, okay. Second statement says that NALSA, National Legal Services Authority, was given a constitutional status, or it is basically a constitutional body under Article 39A of the Constitution. Is that true or false? First statement, true or false? First true, because it provides equal of these things. What is second statement? NALSA is a constitutional body. Is it true or false? False. Then what is NALSA? NALSA is a statutory body. Which of they will give 4 to 5 organizations names and they will ask which of the following are constitutional in nature, statutory in nature. Statutory, there are 2 important bodies, Andy. First one is constitutional body. Second one is statutory body. What are constitutional bodies? Constitutional bodies means Constitution itself has created. Those bodies which were itself directly created by the Constitution or which were inserted in the Constitution is called as the constitutional body. And example is, are you aware of CAG? Sorry? Good creativity. Okay. CAG is Comptroller and Auditor General. Comptroller and Auditor General. Okay. Let me tell you the body which you know rather than giving very big names. Is it a constitutional body or a statutory body? Is it? UPSC, the exam that we are preparing for. The first and foremost basic question. Don't say it wrong because its ego will be hurt. Isn't it right? They don't know even whether I am constitutional or statutory, but they are preparing for my exam. Is it constitutional or statutory? Constitutional? Pakka? Correct. So that means Constitution of India have itself directly created. Some other bodies are like Election Commission, Union Public Service Commission, Comptroller and Auditor General, Attorney General, Advocate General. All these are all constitutional bodies. That means Constitution itself has directly created those bodies. Then what are statutory bodies? It's created by itself? Okay. Statutory body is basically taken from a word called as statute. Means law. A body created through a law is called as statutory body. Okay. So that means now can I say National Legal Services Authority is a constitutional body. True or false? False. False. Why? Because it was created through a law. Which law? Which law? Law name exactly, act name. Legal Services Authorities Act 1987. Because of that particular act only this body was created. Whenever a particular body was created through an act made by Parliament, okay, in this context Parliament has made a law to implement Article 39A, so that is called a statutory body. Clear? Perfectly fine. So, the some other important questions from NALSA. Consider the following statements about National Legal Services Authority. That is how they will frame the questions, Auntie. Accordingly, you should understand first important point that it has been constituted under the Legal Services Authorities Act 1987. So, okay, they will tweak the statement and they say that National Legal Services Authorities was constituted under Advocates Act. They'll confuse it. It's a trap. Not Advocates Act. It was Legal Services Authorities Act 1987. Okay, you should understand that point. Second point. What is the objective of what is the objective of NALSA that is created under Article number 39A of the Constitution? What is the objective? To the weaker sections of our society. Isn't it right? No need to the rich people, right? We need not to provide the rich people the legal services. Therefore, we will be organizing these things. And low adalats in order to settle the disputes, very, very petty small disputes. This is important. The Chief Justice of India is the patron-in-chief of NALSA. Here they will ask you, they will just tweak it. Point number 1, NALSA is a constitutional body, first statement. Second statement says that Union Law Minister is the patron-in-chief of NALSA. Third statement, okay, we'll come to the third statement again later. Okay, fine. So first statement, true or false? False, because it's a statutory body here. Connected through which act? Legal Services Authorities Act 1987. Then second statement, Union Law Minister is the patron-in-chief. If you don't know about NALSA, just tell me, do you feel that that statement is true or false? True. You feel that that statement is true. Because legal services, that means law only, obviously legally only. In government we have law ministry. So union law might be obviously logical. It is clearly logical. But immediately that's a trap. You feel that you have marked it correctly. But there, when you come out of these things and check the key, then you will understand that only true, second statement is false. Because it is the Chief Justice of India who is the patron-in-chief. So Chief Justice of India, who was the present Chief Justice of India? Chandrachud andi, D.Y. Chandrachud. You are no need to bother about names. Okay, they will not ask you like who of the following are Chief Justice, because this Chief Justice will again by the end of 2024 he will retire and somebody else will come. Don't worry about persons, appointment persons, no need of those particular appointments. But the crux, the behind the person thing, he is, whenever somebody, that means whenever a new Chief Justice comes, for example tomorrow if you are the Chief Justice of India, then you will be the patron-in-chief of NALSA. Yes? Then, so this NALSA has patron-in-chief, that means the main chairman, and there is something called as executive chairman. Second important point, executive chairman. Yeah, who will become the executive chairman? Here I just left the third statement, right? Here they might give you correctly, like Chief Justice of India is the patron-in-chief. But the third statement they will give you, CJI is the, or Union Law Minister, just a minute. Union Law Minister will be the Union Law Minister will be the executive chairman of NALSA. Now you may feel this is also correct. This is false. Okay. You are aware now that Chief Justice is the patron-in-chief. You are very aware that it is a statutory body and constituted through Legal Services Authorities Act 1987. You are also very clear that Article 39A to implement this particular provision. But now they will ask, executive chairman is basically the Union Law Minister, and They will ask you the Roman number 1, how many pairs of above statements are correct? Only 1 pair is correct, only 2 pairs, only 3 pairs, none of the above. So that means you should know each and every point that was given in the question. You cannot eliminate here. That means you should mandatorily know that who was the executive chairman of NALSA. Executive chairman of NALSA is, he is the patron in chief already. So the next one, most, the senior most judge of Supreme Court. Whoever will be the next senior most after the Chief Justice of India, who is the number 1, he will be the executive chairperson. Clear? So, point number 1, Article 39, promote equal justice to all the people and provide free legal aid to the poor population. Number 2, according to implement Article 39A, the Parliament has enacted Legal Services Authorities Act 1987. Okay. Accordingly, it has established an authority called as National Legal Services Authority. National Legal Service Authority patron in chief will be Chief Justice of India, and the senior most judge of Supreme Court will be the executive chairman. Now can you tell me at the state level who will be the patron in chief of State Legal Services Authority? Concerned High Court Chief Justice will be these things. So they will not ask about NALSA. They will come down. Consider the following statements about State Legal Services Authority. Point number 1, they will give you the union, the state minister, whoever is concerned, or the chief secretary is basically something they will give you like that. At state level, the same logic, whatever at central level will be the same logic. So that means whoever the Chief Justice of that concerned High Court will be the patron in chief of the State Legal Services Authority. The senior most judge of that concerned High Court will be the executive chairperson of the State Legal Services Authority. This is all about Article number 39A of the Constitution. Done. Then comes, so we have covered 3 important articles of Directive Principles of State Policy. Number 1, Article 37. What is 37? Directive Principles of State Policy are not justiciable, not enforceable through court of law, but however they are fundamental in the governance of our country. 38. It is the duty of the state to promote the welfare of the people and to secure the social, economic and political justice to all the people. What is 39A? 39A, to promote the equal justice and to provide free legal aid to the poor population. NALSA came, SLSA came, legal service authorities came, and all that stuff you should be aware completely. And I have given all these things in your handouts so that you can read them. And if you feel that to make notes from out of that particular handout, you can freely make it. Okay. Next important is Article number 40. Article number 40 is all about the local self-government. It is one of the Gandhian ideology. So in order to fulfill the dream of Mahatma Gandhi, that we have to strengthen the grassroots democracy, we have to give them the more powers. So article number 40 was inserted in the constitution. Article 40 says that organize village panchayats and give them the more powers so that they can themselves work independently. No need to depend on us. Even for a small petty problem, why they should depend on us? They have to take their own decisions independently. When they will take? When they have sufficient financial powers, then they will take. Or otherwise, they have to depend on us. So that means give more power to them, not responsibility. Responsibility is fine. We will all be always giving. But give power to them. That is what is Article 40. It is the duty of the state to organize village panchayats and to give them more powers so that they can function as the self-governments. According to Article 40 of the Constitution is a directive principle of state policy that directed the state governments. As we said, right, it is a direction given by Constitution. State governments to organize the village panchayats. The article also stated that the state should take steps to organize village panchayats and give them the power and authority to function as the units of self-government. So because that is the vision that we have to fulfill. How can I take? So do Constitution has done something? I mean, government has done something to implement this, or it hasn't? They haven't done anything. Yes. What is 11th schedule? What is 12th schedule? What is 73rd Constitutional Amendment Act 1992? What is 74th Constitutional Amendment Act? What are the answers to these questions? Panchayats. 12th schedule is municipalities. 73rd Constitutional Amendment is giving the constitutional status to panchayats, and the 74th is giving to status to municipalities. That means the government is implementing of the constitution. Okay, so the government is saying the same thing. Constitution has given me some direction. Please organize some village panchayats. Okay, and at the same time you have to give them more powers. Accordingly, we have made this 73rd Constitutional Amendment, 74th Amendments, and we have given them the constitutional status. We have given them the sufficient required powers which are required so that, but however, it was not done in a truly complete letter and spirit. To an extent, it was done. So, but still more improvements are required so that they can completely function as the local self-governments, is what is article number 40 of the Constitution. The same thing that we have written here. Through the 73rd Constitutional Amendment Act 1992, government fulfilled the constitutional obligation that is stated under article number 40 of the Constitution. Number 2, a 3-tier Panchayati Raj system was introduced at the village, block and district levels in almost all the parts of our country. When we are discussing the panchayats and municipalities, we will discuss the deep, like what is organizational structure and all those aspects. Yes. What is article 46? Article 46. Sir, you have any reservation? SC reservations are there in our country? In government jobs they are there. ST reservation? OBC? Even the latest women? But however it is in parliament and all representative way, fine. Okay, so SC, ST, OBC, are you aware of this? EWS reservation as well? Yes. Why the government is doing all that? Who said to the government to do that? Constitution have said to the government. Under which article? Yes. It is the duty of the state that it has to prioritize, please prioritize and promote the educational and economic interests. Economic interests means employment. Okay, and employment of the weaker sections of our society. This may include scheduled castes and scheduled tribes. The state should also protect these groups from the social injustice and exploitation that they have made from the centuries ago. Whatever they have undergone, that has to be corrected. That is what is article 46. And regarding article 46, reservation policy in India, one very important topic, Andy, reservation policy in India, like fundamental rights, how they are providing reservations through that. Okay, in directive principles, what is the direction? In Lok Sabha representation, okay, in state legislative assembly representation, we have to discuss all this as a chain of incidents. What are the Supreme Court's opinions on this particular thing? For example, 10% EWS reservation, this was challenged in Supreme Court. And recently in the particular case called as Janahit Abhiyan versus Union of India case. In this case, Supreme Court has upheld this 10% EWS reservation. So, okay, the petitioners has argued that this 10% reservation is unconstitutional. Please don't give them to those particular people, because only on social ground and economic and educational ground only we have to give the reservation, not on economic ground. You are giving on the basis of income, like less than 8 lakh per annum, then you can avail the EWS reservation, again considering other factors as well. So this was challenged in the Supreme Court of India. Then Supreme Court in this particular case called as Janahit Abhiyan versus Union of India case, it has upheld the EWS reservation. Now the question comes here. Consider the following statements regarding the economically weaker sections. EWS quota, point number 1. A 10% EWS quota is provided to the economically weaker sections of our society. That is statement number 1. Statement number 2. Recently, the Honorable Supreme Court of India have struck down the EWS reservation, saying that it is unconstitutional in nature. Which of the above statements are true or false? Or which of the above statements are true? One only correct, two only correct, both 1 and 2 are correct, none of the above. One only correct. Because 10% EWS is providing with reservation based on economic criteria. But number 2, Supreme Court did not declare it as unconstitutional. It in turn declared it as constitutional only. And the case name they may ask you, and it is Janahit Abhiyan versus Union of India case. So Article 46, much more to these things, Andy. For example, I'll just give you basic cases that we will be doing in the foundation batch. First one is Champakam Dorairajan versus Union of India case. The issue started there. Then it went to Champakam Dorairajan versus Union of India case. What is happening? Oh, okay. Yes, fine. So Champakam Dorairajan case is one such important case. Indira Sahani, which is also known as Mandal case, which is very important. Jarnail Singh case, very important. Okay, Nandi? Ee case laws anni manam chadavalannamata. Reservation policy gurinchi, when we are reading about reservation policy, we need to be completely thorough with all these things, cases and some other constitutional amendments. All these things we will discuss in the foundation batch, what is all required for article number 46 of the constitution. As of now, you should understand that article 46 is basically that state should promote the educational and economic interests of the weaker sections of our society, particularly the scheduled castes and scheduled tribes, in order to correct the social injustice and as well as exploitation that have been meted to them. You should know that's it. We will see this as the last article. Article number 49 of the Constitution is all about monuments. Historical monuments, whatever there, that has to be protected. Protected by whom? Protected by the government. This is a direction issued by the Constitution. So the cultural heritage is very, very important. Whatever these monuments, historical monuments which are of national importance, need to be protected by the government. Accordingly, the government is protecting these things, and that direction flows from Article 49A of the Constitution. Yes, these are the important directive principles of state policy that we have to understand. 37 we talked about, 38 we talked about, 39A, then we gone to 40, and then we went to 46, and then to 49. But however, again, there are so many gaps are there, like in 39 some other articles are there, 36 is there. So we will all be discussing later in this advanced classes, we will be discussing all those particular things. Okay, Nandi? Bas, tomorrow we will do the questions. Okay, so we'll stop it here for today. Okay, thank you so much. Thank you, Andy.